I'm thrilled to welcome our guests today, Sydney Bruce and Ephraim Olson. Sydney is the founder and CEO of Mod HR and a trusted partner within the fractional HR space. Ephraim is a tax attorney who founded his own law firm at the beginning of 2020, which has now become a partnership, Olson Harnish Law. Welcome, Sydney and Ephraim. We're excited to hear from you today.
Thanks. Thanks so much.
All right. Sydney, do you want to do anything here or go to the next slide?
No, you're good. If you want to introduce.
Yeah, so let me just do a quick introduction. So my name is Ephraim Olson. I am a tax attorney, graduated from Harvard with my law degree, and am a candidate for an LLM in taxation, a master's of tax from NYU, and I practice tax law.
Perfect. So I'm Sydney, and Dana did a great job of kind of explaining who I am and what I do. We support local businesses and on all their HR needs. We just kind of jump in and lend an extra hand. And I am so excited to be here today and to join forces with an attorney. Even if you want to go to the next page, it's kind of a great segue into human resources and or versus legal. I feel like there has always been kind of this weird tension between HR and the legal space. When do I get an attorney involved, or how much can an HR professional really handle? And I can trace this back all the way to, about 18 years ago, 2003, there was a president, the president started a task force to really have the ABA, which is the American Bar Association. Did I get that right, Ephraim? Create and update a new model to define really what the practice of law looks like. And the tension really kicked in when the new model, the definition really didn't define what unlawful law practice works and looks like. And so you might be asking yourself, well, how does that relate to HR? And I think that I've got a quote here listed from Susan, who was the president of SHRM back at that time. And she said, HR professionals represent employers before countless administrative bodies, including unemployment insurance boards, labor boards, human rights agencies, and the Department of Labor. They are also regularly represented employees in arbitration and mediation proceedings. And so you can see where this kind of friction would come from. Can an HR person go and handle your disputes in front of the Department of Labor, or does it have to be an attorney? And after lots of litigation, basically what they decided was the ABA was going to withdraw its definition of the unauthorized practice of law as it relates to these HR professionals, and basically pushes it down to the state to handle, which means like everything when it comes to people, it just made it a gray spot. So even on the next slide, I have, should I get an attorney involved? When should that happen? I mean, if you can answer yes to any of these questions here, the answer is call an attorney, which is the first one is, are there legal ramifications tied to this decision? And we're going to talk more about this as it relates to independent contractors and employees. But if the answer to that is yes, then you want to save, you want to save face and make sure that you have legal advice behind whatever decision you're making for the organization. And if you're confused or unsure of the legal ramifications, just call an attorney, bring someone in, get some help. And can I benefit from a second opinion? And I think, most of the time we can. And so I'm excited to be here with Ephraim today so that we can kind of show how we come together from the HR side and from the legal side. Ephraim, did you have anything you want to add on that?
Yeah, I just was going to say, I would just sort of agree with what you said, Sydney. Obviously there's lots of decisions and lots of things that happen on the HR side that I don't get involved with, or attorneys probably don't get involved with at all, that strictly in the realm of HR. But there are certain things when it comes to some of these larger issues like employee versus contractor. The ramifications could be quite severe, and we'll show you later in the slide, but it can potentially have criminal penalties, and it can be very, very expensive. And so it just seems like to play it safe, especially on something that's this large, it really does make sense. And getting a consultation or talking to an attorney makes a lot of sense for a lot of reasons, just because it will almost certainly be less expensive than trying to do it alone and then sort of dealing with the consequences after.
Yeah. A couple $100 for a consultation, or in some cases, even when I know this firsthand, millions of dollars if you don't. So big change there. So
yeah, and I just want to sort of go to the next slide here. If that's is that All right, Sydney. Yes. So I just wanted to let you know that, we're talking about these things, but neither Sydney nor I are going to give you any legal advice here. We're just trying to outline an area of the law and sort of how it's been interpreted and stuff. So don't go home with this and try to do it yourself, because that would be a very bad result. And again, there's nothing in here that sort of makes client solicitor, attorney-client relationship. So don't go ahead and share your dirty secrets in the chat, because that won't be protected by an attorney-client relationship, unfortunately. So that's just a little quick disclaimer, and then on to the next.
Yeah, let's just give a quick high-level overview of what we're going to be talking about today. Basically, we're going to drill into the difference between a contractor and an employee, and how that works from a tax side. Is it something, from the state side, and then also from the Department of Labor. So we're going to dive down into that. How do you identify it? How do you fix the problem? I kind of just answered in the who cares. Those are kind of the three different branches that matter the most. It's going to be IRS, Uncle Sam, Department of Labor, and the states, the three things you never want to mess with. So that is the overview of the next 30, 45 minutes. So the number one question I get asked all the time when it relates to this is, how does Uber do it? If you watch the news, or if you've been following this debate back and forth on contractors versus employees, Uber has been all over in the news. And to answer that question, it is very unclear. In a lot of situations, Uber is able to treat the employees like contractors. But then, when it comes to California, that's not quite the case, and which makes sense. We know that California is very much employee centric. So it comes down to state by state laws, and yeah, it's not a clear cut line. Ephraim, do you want to?
Yeah, no. So I just wanted to sort of follow up on that. It does go back and forth, and it depends on the state and it depends on the country, right? So on here it talks about in the UK recently there was a court case that ended up in the news that the UK High Court found that Uber drivers were employees, and my understanding is that Uber is going to sort of respect that and treat their people like employees in the UK. And so, we just sort of highlight this because it is a bit of a gray area. And even a really big company like Uber, we're just using them as an example, but even a big company like that, there are gray areas, and there's courts that disagree, and it's sort of, maybe on the edge, I don't know. So yeah, I want you to keep this in mind as a sort of test case, because we'll come back to it at the end to have you think about, as we go through these tests, are Uber drivers contractors? And a lot more importantly, are your workers contractors? You know what I mean? Or the people you work for, are they contractors or employees? So we give this as a test case, but we want you to think about it in terms of your own situation and sort of how does this work? And we will come back to that. At the end. So the first branch that cares about this is the IRS. So the IRS, obviously, I think Sydney talked about it earlier, but the taxes are a little bit different. If you pay an employee, you pay a little more tax than if you pay an independent contractor. And who pays the tax matters. That an employer has to withhold certain taxes and pay them on behalf of the employee, whereas a contractor is generally responsible for their own paying their own taxes. So the IRS cares because there are more taxes to be paid if they're employees. The IRS has their own sort of three-prong approach that they look at when they're deciding whether someone is an employee or a contractor. And the three prongs are: what is their behavioral control? What is the level of behavioral control? What is the level of financial control? And what are the other indicia of the relationship? What does the relationship look like outside of that? And like I said, the difference is that being a contractor versus an employee does create a different tax treatment. The penalties for misclassifying employees at the IRS level. Now, each of these levels of government have their own set of penalties, but the IRS one can be quite severe. So just some examples or some amounts. It could be up to 20% of the wages paid. It could be 100% of the employee FICA taxes that were not withheld, 100% of the FICA taxes, the employer FICA taxes that were supposed to be withheld. And those could be collected against not just the company, but responsible people that should have been collecting it. There's sort of late filing penalties, there's underpayment of taxes penalties, and depending on how egregious it is, they can be quite severe. And then there's also a late payment of taxes penalty. So you add all those up, and probably they don't all apply, and they, it depends on the situation and stuff. Each situation is different, but you just see the numbers there. It could be quite high. It could be sort of a pretty significant percentage of the wages themselves.
I'm just going to add, you said a really, something that woke me up when we first started diving into this was the reasonable person can be held accountable for that. And so for my HR people on here, that's you. If you're the HR director and you should be the person that knows what these classifications look like, potentially that could come back personally on you for these charges and these fees. So yeah, anyways, we can go to the next slide. So Ephraim just talked about the 3 different ways the IRS tests, and I'm going to dive into the behavioral control. So a worker is an employee when the business has the right to kind of control how the work is done, where the work is done, and when the work is done. So behavioral control categories are broken down into these following bullet points. So I'm going to talk you through these and give you a couple examples. So the first is kind of relates to the type of instructions that's given to the worker. So if you're deciding, hey, you need to be at the office from 8 to 5, 3 days a week you're in office and 2 days a week you're at home, and we're going to provide you with a computer and your office Outlook or your time keeping mechanism. That is all going to, those are all examples of how you would indicate more of an employee. Usually a contractor is going to be the one that's responsible for, they're not going to, where they want to work, how they want to work, and at what time. So the degree of instruction is also going to be another behavioral control category. So really what this is talking about is, does the worker have to follow specific instructions on how they complete their task, their job, their day-to-day? And so this is really going to be like medical professionals or in the finance or the factory industries. You have very strict guidelines and a high level of degree instruction on how you complete those jobs. So again, that's going to lend more towards an employee, where less detailed instruction is going to be more for an independent contractor. So the evaluation is also the next step. So that really depends on, for an employee, usually you're going to evaluate how the work is done and at certain points throughout the project. Where an independent contractor, you're usually going to focus on just the end result of the work that's performed. So for me, like an HR director, as an outsourced consultant, it's just going to be the handbook that's delivered at the end of our project instead of maybe every piece throughout. So those are some examples on the behavioral control. Ephraim, do you want to talk us through the finance control?
Yeah, and let me just sort of back up even just for a second. Again, the overview is, maybe this is clear, but if not, it is sort of a spectrum, right? That on one side you have employees, on the other side you have contractors. And the question really often does come down to control and who's in charge. And is the person independently in business for themselves and coming to you to do projects and stuff? Or are you the only person that they're giving services to? And are you the person that they've first given services to? And are you providing the licenses? And so sort of across the spectrum, there's lots of places on that spectrum, but it often does have to do with control to try to determine, are they in business for themselves and therefore more likely contractors, or are they not in business for themselves and sort of working for somebody else, at which point they're more likely to be employees. So again, that's sort of what we're talking about. These, as you get into the details, just don't forget that the broad overview is the control. The more control you have, the more likely they are to be employees. The less control that's exerted, the more likely they are to be contractors or potentially contractors. So going to the financial control, again, this is the second branch of the IRS test that they use. Does the business have the right to direct control the financial and business aspects of the worker's job? So again, who pays for the equipment, and how significant is that equipment? Are there expenses that the worker incurs that may or may not be unreimbursed? So, could they lose money? One of the things they look for, could you lose money in this? Or are you guaranteed some sort of a gain because your expenses are covered or reimbursed and you have a salary? Is there opportunity for profit or loss? Are your services available elsewhere in the market? independent contractors usually work for lots of people, or have the option of working for lots of people, or could work for lots of people, or have in the past worked for other entities. So sort of, again, that looks to where on the spectrum that they might fall. Method of payment as well is one that employees are guaranteed a payment, usually regular wages paid on weekly or biweekly or monthly sort of, time frame. Even if there's a commission involved, that's, it's still often paid at a certain time. Independent contractors are usually more, it's more of a business relationship, that it's paid by a job, or it's paid by a flat fee or something else that, again, there's opportunity for gain or loss independent of just sort of spending time there.
Yeah.
And then the last one is the relationship. What does the relationship look like otherwise? So what did they call it? Did they call it an independent contractor relationship? Did they call it an employment relationship? So they look at the written contract. What kind of benefits do they offer, right? Employees often have more benefits than contractors. And so what types of benefits are being offered? And that might help shed light on what this is. How long is the relationship going to be? Is it sort of an indefinite contract to continue to get paid, weekly through sort of whenever until it's terminated, or is it a task by task type of a contract that, I'm having someone come replace my roof? That looks different than hiring someone to do a certain job sort of indefinitely until the contract is terminated. And then what types of services are provided, right? Again, is this a type of service that is important to the business? Like, is it an integral part of the business? And if so, it's less likely that it's going to be contractors that are running it, because, again, the IRS sees it as you would likely have employees running the sort of core part of your business, because you don't, you have to rely on them and stuff, and you want them to be there and you want them to stay there. And so the more sort of core to the business's functions this activity is, the more likely it's going to push it towards an employee relationship. And the more fringe it is, right? Again, it's sort of someone replacing a roof that's not part of my business or whatever, and that can be done one-off, and then and then sort of move forward, and that again pushes it closer to a contractor.
So let's hop into the Department of Labor. And so you might be thinking, why does the Department of Labor care? Well, there are several laws that they're responsible for as it relates to employees. So the most, obviously, you're going to talk about your minimum wage and your overtime laws. If you've got employees that are working 42 hours in the state of Utah, you're going to be required to pay them 2 hours of overtime, right? And a minimum wage each week, or for their hourly rate. Where if you're an independent contractor, you're going to be paid for the project as a whole, usually, and you're not, you don't have to pay your independent contractor overtime. You don't have to pay them that specific minimum wage that's directed federally and on a state level. And so the penalty for misclassifying the employees and contractors can equal any overtime that should have been paid, like 1.5 times that rate for any hours over 40 hours a week, which is huge. We've had clients where we have seen this in the millions, where overtime was not paid. And so they had to go back and pay 1.5 times whatever that overtime amount was for all of the employees for that entire time they were classified incorrectly. So this is huge. Courts can award an additional 100% of the unpaid overtime payment that should have been paid. So that's in addition to that 1.5 times the normal wages for the overtime. So this, again, is one of those things that can come down to criminal charges. I believe in Florida that this is a felony. It can be considered a felony if you're not paying these. So this is a huge one. Ephraim, do you have anything to add on that?
No. I think we should just go to an example again. So, like, if this is an issue, you're gonna want to have an attorney working through each of these elements of it, Department of Labor, the state, and the IRS, probably, because you may have exposure on any one of those or all three of them. But like Sydney said, this is just, again, the test is similar in the sense they're looking for does it look and sort of smell like a contractor relationship, and does it have the indicia of that, and is that what the control is, or does it look and smell more like an employee relationship? And that's true for the IRS, the Department of Labor, and for at the state level. But they have slightly different tests, and they look at it different, and sort of giving you some examples is just meant to, yeah, do exactly that. Just give you an example of some cases that have come down. So here's a case that that was dealt with a Department of Labor test. And it was a Sixth Circuit case. Sorry, they were just citing a Sixth Circuit case, and they found that the Department of Labor definition, or the laws that that they are enforcing, that definition is broader than just normal common law definitions of contractor employee distinctions. And so in this one, they found these people in this, they found these workers to be employees, not contractors in this case. And they looked at the following cases, or the following factors to that, among others. They looked at how long the relationship existed between the parties, and it was sort of longer than shorter. The degree of skill required rendering the services, that played into it. The more skill you needed to give the services, the more likely it could be a contractor relationship. The extent of the investment in the equipment and materials. My recollection is this case, they did not give a lot of investment in the equipment and materials. A lot of that was provided by the company. And then the worker's opportunity for profit or loss. And again, this cut, again, my recollection is it cut against the, against the contractor definition, and sort of closer to a employee definition, just because the workers got paid every week or every other week or whatever, and their chance of actually losing money here was quite low. And then degree of control and the manner of which the work is performed, and the types of services, how integral it was to the business itself. And in this case, it was the business. It was very integral to the business's sort of core mission and what it did. And so that cut, sort of pushed it towards the employee designation. So there again, just an example. Again, don't go home and try this trick on your own, but just sort of give you an example of what the courts are looking at. What are they? How are they sort of handling these? What factors matter?
So the states, that's the third and final prong that we're going to talk through. And why is it important that the states are looking at this? Well, as an employer, you are required to pay into unemployment insurance for employees, but not for contractors, and then worker compensation benefits as well. So that all comes to, the states are going to have a vested interest in this, because they want to make sure that they have funds for the injured and the people that are out of work, so that they can participate in those safety programs rather than rely on the state for the aid. So they have a vested interest to make sure that all of the employers are paying what they should be into each of these programs. Penalties for misclassifying employees can be extremely severe on this side as well. And again, they can include criminal sanctions, including felony charges. So this is one, again, you don't want to mess with. I think they're the three branches you really don't want to mess with in government at all. And so, yeah, I think. Oh,
Sydney, I'm just gonna jump in on that as well. So the state one, in some ways, is a little bit trickier than Department of Labor and IRS, because it's state specific, right? So just keep in mind that where you're located, where your workers are located, where the business is located may have a factor here, right? That different states have different rules, and they have different timing, and they have different penalties, and they have, what you have to pay for and not pay for if you're an employee or contractor. That some states may have you give certain benefits to contractors or whatever. So this is sort of again, just sort of a teaser, in the sense that each state's going to be a little bit different. You have to look at that, think about that. But the state they do have a vested interest in doing this right and having you classify people correctly. And just so you know, a lot of these a lot of audits come out of people applying for state unemployment benefits, right? It's sort of, you let somebody go and they don't find work, they go and apply for unemployment benefits because they sort of think they should have access to them. And if they do, the state will often look into it and say, well, why do you think you should have unemployment benefits? And talk it through. And then that often opens up audits. So again, the state has a vested interest in this because people do show up at their door asking for benefits that they can or can't give sometimes, and sometimes have to pursue employers so that they can get these benefits. But just so you know, that's sort of what's going on here at the state level, is that the states have a vested interest to make sure their people are taken care of, and that they're not, relying on state aid when they could be relying on a program that's set up specifically to do this.
Exactly.
And so that's something to think about. The other thing just to know is that many states, or some states, have a sharing agreement with the Department of Labor, so that if the Department of Labor opens up an audit, they'll share everything they learn with the state, and vice versa. So if somebody knocks on a state door looking for unemployment insurance, and they open up an audit and they look through things, there's a possibility that all ends up with the Department of Labor. And they can do their own research, and anyway, so there can be sort of passing of information between the branches, and you should just be aware of that. Again, this one is actually an example from a state level in Utah. It's one of the courts in Utah, about looking at how whether this worker was a contractor or an employee. And the Department of Workforce in Utah determined that it was an employee, not a contractor. The contract said she was a contractor. She still provided some stuff like her home office and a computer, but most of what happened was the firm's software, which was quite valuable, that she did not provide, and that was obviously provided by the firm. She was paid weekly. She worked full-time here, so she sort of wasn't holding herself out for business elsewhere and stuff, which isn't necessarily, but it did cut towards it being an employee. And then she did not have her own business. She didn't have her own employee identification number or anything else. And there's other factors, but those were some of them. And they looked at it and they said, we think, even though the indicia was that she was a contractor, that you said she was a contractor, she signed a contract saying she was a contractor, the other stuff, it smells a little bit more like she's an employee. They found she was an employee. And then the Court of Appeals in Utah affirmed it. And they said this, which I think was interesting, that Utah law presumes that a paid or contracted worker is an employee unless the putative employer can demonstrate that the worker is independently established in a work of the same nature and has been free from control or direction over the means of performing the work. So, and then sort of going on, special scrutiny of the facts is required to assure that the form of a service relationship does not obscure its substance. If an employer fails to demonstrate either independent establishment or freedom from control, the worker is considered an employee and may be entitled to unemployment benefits. So again, Utah is different than other states, and this is one case out of thousands or hundreds or whatever. But again, just to give you an example that this is what they're looking at, this is what they're looking for. And we'll come back to this in just a few minutes, but think about, as we go through these tests, how does it relate to you or your people or the people you're advising? Are they clearly on one side or the other? Is it gray? Does some indicia cut some way and some cut the other? So that's something just to keep in mind. So yeah, I guess I asked the question too soon. So we come to this sort of question and answer, but before we start that, or as we start that, I want you to think, are Uber drivers contractors? Well, I don't know enough about Uber to say, to be honest. I just read the news like you do. But those would be some of the indicia that the courts would look at in the states and the Department of Labor and the IRS. Is there control over the driver? Are the drivers independently sort of in business for themselves? Is there financial control? How are they paid? Who pays them? What benefits are given? What do they call themselves in the contract? How long do they work? Are the contracts indefinite, or is it for a certain period? Or it'll be those sorts of questions likely that will, decide over time whether these people are contractors or employees.
And so for Uber, it came down to the control, right? The employee or the contractor, in a lot of senses, the main thing, can they go in and they pick their schedule? So if you're trying to figure out, is it in a 1099 or a W-2, you can ask yourself some of those questions. Do I issue a schedule, or do I allow those contractors to work whenever they want to? How are they being paid? Are they being paid through my payroll system on the same payroll run as all of my W-2s on that same cadence? Or do they submit invoices that I approve and then issue payment to? So those are kind of the practical application side of those tests. And then it's just the weight. yes, yes, yes on this side, or no, no, no on that side for contractors and employees, kind of see where you fall.
And again, can I just jump in one more time, Sydney, for a second? I work with like with other attorneys that deal with this. I work with people, and so often this doesn't come up until it's an issue, right? People don't sort of think through where this is going to lead, and so they end up, once there's an audit opened, or once there's a penalty assessed, or once something's happened, and those penalties can be very large. And I just wish I could talk to them in advance and say, hey, before you decide to pay 1099, or before you decide not to pay 1099, go talk to somebody, go hire, retain an attorney, and just go through your situation and figure it out, because that will cost you something. But I can almost guarantee you it'll cost less than enforcement on the other side if you're wrong. So I just can't say enough times, please go get help if there's any question.
You guys are doing the first step by joining today, so that's great. Dana, do you want to start? Are there any questions that have been submitted? I think I've seen some come through.
Yeah, we do have several questions. So I'll go ahead and jump in with one from Rachel. How do we appeal to get a status change from employee to independent contractor?
Oh man, that is a great question. Ephraim and I just had a client, we went through this exact same thing, and I'm going to let Ephraim kind of go with more detail on this. But when it comes to the status change for the employee, all I can say is I would definitely you're going to want to do the duties test on all three of those areas. So your state, your Department of Labor, and figure out where do you fall, analyze what your penalties are going to be, and then make a decision going forward as far as should we adjust. There's a lot of different ways that you can correct that. So Ephraim, let's.
Yeah, no, I was good. Mine's something similar, right? So what you want to think about those areas of liability, it's IRS, it's Department of Labor, and it's state. So depending on your state, and you probably want to get somebody involved in you probably want to get an attorney involved just to think through, because some states and some programs, the IRS, for example, does have ways to come clean. And depending on what your exposure is, you can come clean for a lot less than you would if they caught you. And so depending on whether you have been approached before, whether you have had an audit in the past about this issue, you may have an opportunity to come clean in some, for some branches and not others. Some states, my understanding is they also have, like Utah, they do have a way that you can sort of come clean and have some of the penalties waived potentially. And so you probably want someone to analyze what your exposure is on all three of those, and what the best way forward is. How do you come clean? Do you not come clean? Do you just change it going forward? Do you go back and sort of fess up and pay the penalties? How close to the line were you? Did you have advice in it before, right? Like, what did you base? Did you base this on a gut instinct? Did you base this on a sort of an opinion from a law firm? That will probably depend on what your exposure looks like. So I know that's not a very good answer, but the answer is go talk to somebody, because you'll want to think through that with them, what your exposure is, what programs are available in your state and sort of Department of Labor and IRS level that you might fall into that could help you reduce the penalties if you do have exposure. If you don't have exposure, maybe you just change going forward and just make sure you're safer going forward.
Right.
I hope that answers the question. I know it's not sort of an answer, but I think a process is the answer here.
Yeah. Analyze where you're at on all three of those levels before you make the decision. And every state is going to have different programs. The IRS has one. One thing, Ephraim, that we could mention is that there have been situations where we have gone with the IRS program, which is like a whole form that you fill out where you submit all of this documentation, your overtime, everything like that. And we move forward with an IRS change, but we don't move forward with a Department of Labor change. We just change it from the date going forward. So there's all sorts of different situations and scenarios that you can piece together. So I'm with Ephraim in the sense that the first step before you start doing that appeal for change is to make sure you have a very detailed analysis of where you're at, what your exposure is.
Just a follow-up question to Rachel. So she's talking about changing an employee to an independent contractor. Do the same penalties apply if you've misclassified the other way, or is it typically you're classifying someone a contractor to an employee?
Yeah, it's usually the other way around, because the employees have more protections than a contractor, and that's where it sort of comes to, right? It's cheaper to do contractor. There's less reporting. There's less there's less benefits, there's less protections. And so for each of these places, by paying too many benefits, you're not going to necessarily hurt yourself. They don't, they would love everybody to be classified as employee probably, because there's more benefits, there's more unemployment insurance, there's more workers' comp if someone gets injured, stuff like that. So you're not too worried about that. It's usually the other way. Often what happens is people have been classified as contractors, but should have been classified as employees.
Right. So if you're going to change, so let's say you have someone that has worked with you, they're going to resign this month, but then they're going to want to work for you on a contract basis and just maybe do 1 or 2 projects for you once every 6 months or every 2 months, then really all you would need to do is terminate them as an employee. And then I would do, get the W-9 and move forward with them as a 1099 contractor, work with your accountant to make sure that you're issuing all the proper tax documents and you're filing the proper tax documents. But if that's kind of one of those scenarios, I guess, where you would go from an employee to an independent contractor. And that's not a hard change to make as long as you've identified that, hey, they can be an independent contractor and they check all those boxes. Hopefully that answers your question, Rachel.
That's great. Thanks for that follow-up. We have an anonymous question around what is the best practice for seasonal workers? So, a lot of our customers for instance, are like pest control companies. They employ people for a set amount of time. They're not working off season. Would you classify them 1099 or W-2?
I think the first thing I would say, it's going to be industry standard and really what that, the control looks like even when they're working for that seasonal time. So there's different routes that you can go. If we say, okay, the control really falls and they do look like an employee, then you can classify them as a temporary employee. There's different contracts that you can put in that place. So, benefits and the things that you're offering are a little bit different than if they are a full-time independent, a long-term W-2 contractor. Long-term W-2 employee versus contractor. But I think it comes down to that control. Ephraim, how would you add onto that?
Yeah, I would just say, I don't think that changes the analysis at some level, that I would still probably get someone involved. And one of the reasons here is that there may be opportunity to have somebody as a contractor or not, depending on, like Sydney said, on the control and the other factors. But the thing to be careful of is that often these types of jobs, people work a lot of hours at a time per week. And so one of the issues you have to think about is, if my person is working 65 hours a week or 70 hours a week over the summer because they're young and they're ready to go, take on the world, or they're sort of enthusiastic and this is what they do, you just have to think about the potential liability there if you misclassify. So again, it's still very important to go get an advice from somebody, get an attorney involved, because misclassifying somebody, you might get to the end of the summer or the end of the season and have racked up 50% of the hours being overtime hours or 40% of the hours being overtime hours. And just at the Department of Labor alone, if you have to pay time and a half for those hours and then 100% of that again, that alone could be just crippling liability. So that's one of the issues, that, maybe there's an opportunity to have somebody at 1099, but the potential liability can be quite high, in the sense that if you misclassify, like I say, I don't know the industry and I can't sort of give sort of specific advice, but I just know that's something you might want to think about is,
right,
overtime could be a big issue.
Overtime could be huge. And like their schedule. So if you're thinking about you said pest control, like that's one client that you guys have that's really great. Are they going to, pick their own schedule? Do they work on, is it just X, Y, and Z projects that they're going to do? What kind of control are you giving them? And in that example, Dina, do they provide their own, pest control stuff, like the solutions and things that they need for that, and the car to get to and from? Or is that something that you're providing for that seasonal employee? So those are the ways that you can kind of break that down and decide best practice for seasonal versus, 1099 or W-2.
That's great. We do have a few more minutes for more questions. If anyone has them, please submit them through your Q&A panel. We do have another one from Kyle. How long does it normally take to convert someone from a 1099 to a W-2? How long is that process?
Sydney, you could say from your side. My guess is a lot of it's sort of logistics.
It's logistics. It's going to be how quickly your team can come together and really do these tests to see where you fall, and then to decide which route you're going to go. Like I said earlier, you can report to the IRS, and then maybe your exposure says, we're not going to report to the Department of Labor, but we're going to change it going forward. One of the plans that we know on the IRS states that, you file for this classification change, and then I believe it's 60 days or 90 days. Ephraim, I can't.
Yeah, my recollection was it was 90 days.
Yeah.
I don't remember, but yeah. So I'll tell you just step by step. You probably want to get like legal advice right at the beginning, and they could do the analysis, and then you decide. And once you decide to pull the trigger and say, yeah, we are going to change things, it still takes what, like probably 3 months, maybe a couple of months.
Yeah, I'd say 3 months or so. You have to go through that waiting period, and then you're going to have them there. In that waiting period, there's a lot of things you need to think about if you've gotten them misclassified and you're going to W-2, because once you hit W-2, you're going to have a whole bunch of other things that you're responsible for as an employer. So in that time frame, while you're waiting for the IRS or whoever, Department of Labor, the state, to approve that change, you're going to want to look up and say, okay, now I had 55 independent contractors. They're all misclassified, and now I've got 50 or 55 W-2 employees. Well, now you're going to be exposed to a whole bunch of other regulations. So there's a lot of things you can do in that 90 days to make sure that you're compliant at the time that they go W-2. So for example, at 50 employees, you're required to give benefits. So you're going to need to be meeting with brokers and making sure that you have all of that teed up. Paid time off, sick leave. If none of them were contractors, all of a sudden you're going to have to make sure you've got the right posters, like all of the compliance things that come along with having W-2s. So those are things to think through and make sure that you kind of have a compliance checklist so that you know where you fall if you do make that transition from 1099 to W-2.
That's great. And does the W-2, do those rules vary state by state as well, or is it pretty standard?
Yeah, that's a great question. There's gonna be different regulations state by state and how you pay them. So that's a great question, Dana. So in California, if you have employees and you make that change, you have to pay overtime at anything over 8 hours worked per day. So you're gonna wanna make sure that your payroll system can accommodate for those things, or, but in Utah, that's not the case. In Utah, overtime doesn't accumulate until you're at 40 hours. Over 40. So yes, it is state by state to answer your question.
Excellent. Well, it doesn't look like we have any other questions coming in. So I think we got to them all. Great job, Cindy and Ephraim. Really appreciate you being here today. As I mentioned, we have recorded this presentation. All of you will get a recording of this in the next couple of days, and just really appreciate you joining us today to learn from these awesome experts.
Thank you. It was great being here.
Thanks, Dana. Thanks,
Thank
Sydney.
you.
Thanks, everybody.
Bye all.